Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 96. Although, to be honest, and I emphasise this is a purely personal view, given the events on the recent Brexit referendum, it's been a pretty depressing time to be British, I think. It really does feel like the time to break out a great national poet who once asked, "What should they of England know who only England know?" Because if ever there was a time for building bridges and listening to facts, rather than building walls and listening to fancies, well, that was it. And anyway, the poet, in case you're interested, depending on your take on these things, is either, or both, Rudyard Kipling and Billy Bragg. And just while we're on the subject, I'm going to do a link to the Kipling poem on what happens when you ignore facts for flights of fancy, and you may think it's equally appropriate. Anyway, amongst a very long list of very serious and constitutionally significant issues, there's the not at all important issue of the scope of coverage for EU cases on this podcast. Presumably, for at least the next 2 years, the European employment laws will continue to apply in full, EU cases will be relevant, and Britain will continue to be required to apply the laws in full. So I'm not going to change the focus of the podcast or the extent to which cases in the European Court will continue to be extremely important. Of course, as most people realise, one of the potential outcomes could see us continue to apply all of the employment rules in return for free access to the European market, so there might even be a longer-term future. So, having said all that, we have 3 cases to look at in this episode. One deals with points in connection with the now very significant litigation involving Asda on equal pay issues. I understand that there are a number of significant cases involving other supermarkets too, where collective equal pay claims have also been brought. It's been a long time coming, but clearly private sector employers are now facing increased pressure on equal pay. Secondly, we have a case to do with early conciliation and what happens when fresh parties are added to litigation. Thirdly and finally, I wanted to pick up on some comments around the Advocate General's opinion on the Muslim headscarf case in Europe. As usual, don't forget that you can access the podcast via iTunes, Mayor Brown Internet or YouTube, and the Twitter feed Nicholas Robertson at NicholasRobert11, which is also where we put out links to the cases discussed, and in this case, the poem. Oh, and finally, and in an increasingly meta move, I have an apology for an apology. All will become apparent. So, first up, Asda Stores and Brearley and others. This is a case connected with the equal pay litigation going on involving Asda. There are apparently, according to the report, over 7,000 claimants, mostly women, all of whom are employed by Asda. They're working in hourly paid jobs in the Asda retail stores, which are these jobs mostly done by women, and they're claiming equal pay with comparators in the distribution depot, which, according to the Court of Appeal's summary of facts or contentions, are jobs overwhelmingly done by men. Well, as you'd expect, the tribunal claims are very complicated. Collective equal pay claims in the private sector have been extremely rare, and this is already throwing up some interesting issues. So why was the Court of Appeal involved? Well, as you would expect, the claimants started their cases in the Employment Tribunal. Asda took the view that the case should be heard in the High Court, and applied to the Employment Tribunal for an order to bring this about. It was common ground between the parties that the Employment Tribunal had no express statutory power to transfer a case to the High Court. Therefore, Asda applied for an order that the tribunal proceedings were stayed indefinitely. They said this would then inevitably lead to the claimants starting proceedings in the High Court, because that would be the only place left open to them. You may remember that claimants have 6 years to start a case in the High Court, rather than the much shorter time periods for starting cases in the Employment Tribunal. This meant there were 2 separate issues, and Asda had to win both of them before it could get its way. First, it had to convince the tribunal that it had the power to grant a stay in order to force the claimants to start a case in the High Court. Secondly, they then had to persuade the Employment Tribunal that it would be the right thing to do to grant this order, even if the tribunal was satisfied it had the power. Well, the Employment Tribunal rejected both arguments. It said it had no power to impose a stay for this purpose. Even if it did have such a power, the tribunal said it would not be appropriate to exercise it in this way. Asda appealed to the EAT. The EAT decided the case was so weak there wasn't even an arguable case. Asda then appealed against that refusal to allow the case to proceed, and when that appeal was turned down, Asda appealed to the Court of Appeal against the EAT's ruling that it had no arguable case. Before the Court of Appeal, the barrister representing Asda made a number of statements designed to show quite how significant this litigation is. The argument was that the litigation, he said, was by far the most important, complex and financially significant equal pay claims ever pursued in the private sector. It would have enormous effect, it was asserted, not only on Asda and its 150,000 employees, but on the retail trade generally. It's also claimed there are complex points involving EU and domestic law, and that, since most of the equal pay authorities are on pay in the public sector, there are some difficult unanswered issues which will need to be considered in this case. And on that basis, Asda submitted it was vital that the case was heard at the highest level, and High Court judges were better placed to address these complex legal and factual issues than employment tribunals. The claimant's response to this is, according to the Court of Appeal, that this is quote-unquote overblown hyperbole, unquote. Claimants agreed the case was complex, but said so are many high-value public sector claims. Well, the Court of Appeal took the view, first of all, that there was no power for the tribunal to issue a stay to compel, in effect, the claimants to start proceedings in the High Court. The express power for the High Court to transfer cases to the Employment Tribunal, but nothing the other way round. Court of Appeal agreed with the EAT that the employees had a right to have their civil claims heard in the Employment Tribunal because there is no statute or rule of law which would permit the tribunal to relinquish jurisdiction in favour of the High Court. They also pointed out that it would be significantly prejudicial to employees if they were required to issue proceedings again in the High Court. The costs regime is different. There might also be concerns about time limits and how far back claims could be brought. They then went on to consider, for the sake of completeness, whether the power should be exercised if there was such a power. The tribunal judge had, if you remember, dismissed this argument from Asda as well. The judge pointed out that tribunals have specialist experience and have been handling equal pay matters for over 40 years. So, in addition to the fact the Court of Appeal found that there was no power for a tribunal judge to make the sort of order claimed by Asda, the Court of Appeal also decided it would not be right, even if the power existed, to make such an order here. So Asda ended up 0 for 2. All of which might leave you wondering, what's the relevance of this case and why have I wanted to talk about it? Well, I think the main point is that for whatever reason, Asda were clearly concerned about the Employment Tribunal deciding these claims, felt it was worth taking the risking the ire of the tribunal judges by seeking to have the case taken away from the Employment Tribunal, transferred to the High Court. But I think perhaps what's more significant are the glimpses it gives us into the complexities of this equal pay case. If there are 7,000 claimants' jobs involved, there must be many times that when you add in comparable jobs. The dispute will cover whether comparators are on common terms with the claimants, whether pay comes from a single source or whether it's from multiple sources. Local variations and the way stores operate make it difficult to select lead cases, and the extent to which pay has been determined by non-discriminatory market forces. All of this points to the fact that, when coupled with the gender pay disclosure regulations, which will be in force from October this year, private sector employers need to be thinking ahead. It's an interesting time. They need to be putting in effort in conducting trial audits to work out areas of weakness and potentially defence strategies. You might be particularly unlucky if you're the next Asda, but you can't deny the risk exists. So that's Asda Stores and Brearley and others. Next up, Drake International Systems Limited and others, and Blue Arrow Limited. This case looks at the ACAS early conciliation rules and what happens where a claimant wishes to add a respondent to litigation, where the claimant has not gone through early conciliation in respect of that potential respondent. The underlying facts were that Blue Arrow took over a contract pursuant to TUPE. It claimed that the transferor had failed to provide the necessary statutory employee liability information, which is to be provided under regulation of the Transfer of Undertakings regs. But there was a problem for them. They weren't sure precisely who the employer was within the Drake Group, so they assumed it was Drake International Limited. They went through early conciliation, identifying Drake International, and in line with their obligations under the Employment Tribunal regulations, they provided the name and address of Drake International to ACAS, and then used that same name and address on their claim form. However, the claim made it clear that they were not certain they were suing the right Drake company, and they reserved the right to join other parties in the Drake Group when this point was clarified. When the grounds of resistance was submitted by Drake, Drake International identified 4 subsidiary companies as being the actual relevant employers. Bingo! So Blue Arrow then apply and are successful in getting an order that those 4 companies are added to the litigation. Drake International appeals against that order. It said the tribunal's decision was wrong, because the claimant, Blue Arrow, had not gone through early conciliation with those 4 companies, And moreover, adding them now would be commencing claims against 4 individual subsidiaries when that was out of time. I can just add in passing, there's no suggestion that the original claim against the top company, Drake, was out of time. In order to answer this, the EAT looked at the purpose of the early conciliation process. Section 18A of Employment Tribunals Act set up early conciliation, and in effect means that in order to start a claim in an employment tribunal covered by the early conciliation process, it's necessary to provide an early conciliation reference number obtained from ACAS. The EAT agreed with the approach which the tribunal here had taken. It's not necessary for a party who's been added to litigation, which has already been validly started, to be joined within the timescale for the commencement of the claim. Nor, they said, was it necessary for there to be a fresh, early conciliation process against those new companies before they could be joined. The EAT, in essence, followed an earlier case, Science Warehouse Limited and Mills, and took the view that early conciliation was simply for parties who wished to take advantage of it to have an opportunity to conciliate, but this was led by the wishes of the claimant. The prospective claimant had to provide names and addresses in relation to the quote-unquote matter. The EAT laid particular stress on the fact it didn't say it had to be each particular claim. It was sufficient to provide names and addresses in connection with the matter. The ability, they said, to add or substitute one party for another in litigation is a case management decision, and it has to be exercised judicially in accordance with the overriding objective. Here, there were strong arguments in favour of adding parties without requiring the claimant to go through an early conciliation process in respect of those new parties to be added. It would cause additional time and expense for ACAS if this process became a requirement. It would be unnecessarily formal, they said. It wouldn't be consistent with the objective of avoiding delay. Drake pointed out that if the 4 companies had been identified before the litigation started, then early conciliation in respect of each of them would have been necessary. In the circumstances, they claimed, it seemed very odd that if they were joined once the litigation was underway, early conciliation was no longer required for those 4 companies. But the EAT, in essence, said that's a matter for judicial discretion. If the party being added had nothing to do with the claim that was being advanced against the original defendant, then a judge might well exercise his or her discretion at the case management stage not to add the new party. The judge also pointed out there was clearly a close link between the parent company and the 4 subsidiaries, not least because they got the same legal team acting for them throughout. Well, I thought the case was useful. It's obviously an unusual one because we don't see many claims involving failure to provide statutory employee liability information, but it illustrates the practical point. Here it was one company suing another company where there was uncertainty about the identity of the employer. But the approach would have worked equally well for an individual claimant uncertain of the identity of his or her employer. And the approach adopted by Blue Arrow in this case was spot on. They identified the nature of the complaint and the uncertainties about the correct identity of the employer in the claim form. This made it, I think, harder for Drake to argue the correct employers should not have been added to the litigation when the identities of those companies was unknown to Blue Arrow at the time the litigation started. Equally, if you're acting for employers and the wrong party is identified on the early conciliation certificate and or the tribunal claim, it would be wise to take account of this particular decision and others which take a similarly hands-off and pragmatic approach to early conciliation. So that's the case of Drake Systems, International Systems Limited and Blue Arrow Limited. I just wanted to finish up with saying a few words about, and I'm going to get the name of this case wrong. I'm going to say it's the ACBITA, I don't know, ACHBITA, and others, the G4S Secure Solutions NV. I really wanted to end up on this one because it's had quite a lot of press attention, and somewhat I'm about to say as a personal view, but at a time when, according to the press, there's increased racist assaults and abuse on people who are perceived to be ethnic minorities within the UK. I think perhaps it's a timely case. And there's no doubt the dress codes, they're very much in the public eye at the moment. Here in the UK, of course, we've had the receptionist case who was sent home failing to comply with the dress code which required her to wear heels between 2 and 4 inches in height. We've had the Awida case, which went up to the European Court of Human Rights, not the ECJ, the European Court of Human Rights on dress codes and the wearing of a crucifix, where the employer's dress code was found to be discriminatory when it banned this. Well, this case is in the European Court of Justice and concerns the alleged religious discrimination issue in Belgium. It's important to note up front that the way that the directive, the Equality Directive, was implemented in Belgium, allows a slightly greater degree of latitude when it comes to justifying direct discrimination and the equivalent legislation in the UK. However, it's the way that the Advocate General approaches matters which is of interest. The claimant was employed by G4S as a receptionist. For the first couple of years of her employment, she didn't wear a headscarf. However, in April 2006, she announced she was going to do this because of her religious beliefs as a Muslim. The problem was, the employer had a policy that its employees in Belgium could not wear any religious symbols whilst at work. This was unwritten in April 2006, but was put into writing shortly after the claimant announced her intention to wear the headscarf at work. And the company written code of conduct provided that employees were prohibited from, quote, wearing any visible signs of their political, philosophical or religious belief, and or from giving expression to any ritual arising from them. So wearing any visible signs of political, philosophical or religious belief. So that's the policy that G4S had. Now, I want to make one thing very clear. The Advocate General's opinion only ever contains a summary of the facts because it gets boiled down into questions to be referred to the European Court. We don't have the full facts. We don't know the full justification that G4S had for its policy. There may have been client complaints. There may have been other problems. In a sense, that's not the point. It's not the policy that's the causes the concern. It's the Advocate General's reaction to the policy and the points that she draws out to rely on for her statements that I think are the cause for concern. So, the claimant doesn't back down, she's dismissed, the case starts, goes through the Belgian court, and ends up being referred to the European Court. We've only had the Advocate General's opinion, so the case is very much ongoing. But the Advocate General makes a number of very important comments. First, in her opinion, the case was not direct religious discrimination, which the Belgian courts appear to assume it was. It was indirect religious discrimination. She noted that throughout Europe, courts have been interpreting similar questions inconsistently, and indeed, it seems that the member states that made submissions on the case also did not agree whether it was direct or indirect discrimination. The Advocate General's opinion was that this was a general rule equally applicable to all religions. Therefore, it was indirect discrimination rather than direct. I suspect this would be similar to the approach that would have been taken in the English tribunals. So far, so good. However, whether it was direct or indirect discrimination, the Advocate General's opinion suggests that the policy was capable of being validated and found to be non-discriminatory. The Advocate General took the view that employers had to be permitted a degree of discretion as to how they conducted business, and that included a right to determine how and under what conditions the operations within the organisation are performed. If employees are in regular contact with clients or customers of a business, then a dress code may set down standards for workers to behave and dress in a particular way, the Advocate General said. In this case, the Advocate General seemed to accept that a ban on headscarves was consistent with the employer's view that it should be religious and ideologically neutral. In considering whether the clothes code caused unfair prejudice to employees, the Advocate General took the view that religion, as a protected characteristic, is different from a protected characteristic, such as discrimination. Race discrimination or sexual orientation discrimination. She indicated that an individual's sex, skin colour, racial origin, these are external and unchangeable features, in her opinion. With religion, it's part of an individual's private life, and so a degree of restraint can be required from individuals in order to fit in with the employer's dress code. Moderation can be expected of individuals. Well, clearly the case is continuing. Can't emphasise that enough. We don't yet know whether the European Court is going to address this. Equally, there is at least one other case pending in front of the European Court involving an employee of a French company who was dismissed, also for wearing a headscarf. There the individual had been the subject of complaints for wearing the headscarf to clients whom she was visiting. So, personal. Is it just me, or does this case leave you with a really uneasy feeling about the illegal analysis being applied here? The Advocate General's opinion recognises that underneath this is a fundamental question as to how much difference and diversity an open and pluralistic European society must tolerate within its borders, and conversely, how much assimilation it is permitted to require from its minorities. The Advocate General recognises this is potentially a landmark decision. To quote the Advocate General, it's groundbreaking in the world of work, unquote. Having said all that, we seem to be in a situation where a receptionist was dismissed for something done in conformity with her Muslim faith. Increasing number of Muslim women will wear headscarves. There's no suggestion in the Advocate General's opinion that any client or customer had ever complained, having been confronted with a headscarf-wearing employee of G4S. Equally, the idea that an employer is able to ban any religious or philosophical beliefs or manifestation from the office is very hard to understand. What is so important about wearing something as a symbol? Is it any different from the receptionist telling someone she's a Muslim? Or telling someone, perhaps, as we have at the moment, that she is fasting during Ramadan? If I put photographs of my wife and kids out on my desk at work, what's the distinction between that and my sitting there with a sign stating my sexual orientation? The lack of evidence for the need for a restrictive policy is quite startling. The employer's policy, unwritten at the time, overrides the desire to manifest religion by wearing a headscarf. Oh, and whilst we're on the subject, headscarves. So, if a bloke wanted to wear a headscarf sitting on reception and said it was nothing to do with being a Muslim, presumably that would have been okay. So it's the subjective intention of the receptionist in wearing the headscarf that makes it offensive. So if she'd wanted to wear it but not say whether she was Muslim, would that make it all right? The policy just seems to be confused, shall we say. And more importantly, the Advocate General's reasoning on this seems to be very unclear. In the British Airways and Awida case, the relevant dress code allowed scripturally mandated items. The problem for Miss Awida was that the crucifix was not mandated in that fashion. BA's policy permitted headscarves. Ultimately, I think the bit that leaves me most concerned is that we as a society seem happy on the basis of this case for employers to tell women what they can wear to work. And the press do seem to pick up on headscarves, rather than, say, turbans worn by men. The upshot is that instead of promoting diversity and inclusion, there's less tolerance, and a woman in Belgium has lost her job because of her religious faith, which asks her not to show her hair uncovered in public. The hijab, the headscarf, is worn by an increasing number of women in the UK. It's worn for reasons for prayer, for modesty. It's specifically mandated in the Quran. And in the circumstances, the acceptance by the Advocate General of a policy that seems to have been based on nothing more than a statement that the employer wished to be completely neutral, even to the extent that's possible. It's surprising that the lack of evidence and the need for that, or the balance between the legitimate desire to follow a religion and the employer's desire to provide goods and services in a particular way, that balance seems to have been lost. Anyway, we will see what happens. As I say, I can't emphasise enough, it's the Advocate General's opinion that we're going from. The full facts of the case are never in the Advocate General's opinion. There's obviously always a précis when the cases get cut down and sent up for specific questions, go up to Europe. So there may well be more to this case than meets the eye. In a sense, it doesn't matter whether there's more to this case on the facts, and perhaps, let's say G4S had strong grounds for the policy because of complaints received from clients, for example. The issue is that it's the Advocate General's reasoning that I think calls out for question, not the G4S policy itself. So, thank you very much for listening, and hope we'll be back in 2 weeks' time. Just two comments. First of all, in the intervening week, we've got a podcast involving Paul Goulding on the subject of restrictive covenants. His new book is out, and Paul kindly agreed to stop by and talk about recent lessons on restrictive covenants, things that have come up in the writing of his book. The other thing is, I have an apology for an apology to make. Apparently, someone had missed my original plot spoiler, heard my apology, and because my apology referred to what I'd done wrong in relation to the original plot spoiler, they found out said piece of information from the apology, not the plot spoiler. So now I'm in the very meta position of having to make an apology for an apology without actually being able to say what the apology is for, so that at least we put an end to it here. So, all clear? Anyway, thanks very much indeed. Take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.